In recent times, there has been growing confusion in Nigeria about trademarks. Many people now believe that once a person registers a name as a trademark, nobody else can ever use that name again. This belief is false. Trademark law in Nigeria does not give anyone absolute ownership of words, names, or natural terms. It provides limited protection within clearly defined boundaries. This video explains what a trademark means under Nigerian law, whether natural words like rattle or lion can be trademarked, the legal limits and restrictions of trademarks, the importance of prior use, what someone like VDM can legally do to retain a name in Nigeria. Under the Trademarks Act, Cap T13, Laws of the Federation of Nigeria, LFN 2004, a trademark is a mark used in connection with goods or services to indicate a trade source. In simple terms, a trademark helps the public know who is behind a product or service and prevents confusion in the marketplace. Trademark protection in Nigeria is territorial, only valid in Nigeria. Class-specific applies only to certain goods or services. Commercial, not cultural or conversational. Can natural or common words be trademarked in Nigeria? Yes, but only in a limited sense. Words that already exist in nature or common language, such as lion, eagle, rattle, tiger, are not automatically excluded from registration. However, Nigerian law does not allow monopoly over generic or descriptive words. Such words can only be registered if they are used as a distinctive brand. They are not used to describe the goods or services themselves, and they do not mislead the public. For example, rattle may be registrable as a brand name for a media platform or technology product, but it cannot stop people from using the word rattle in education, activism, discussion, or description of the animal. The most important limitation: trademarks are class-based. Nigeria follows the NICE classification system, which divides goods and services into classes. What this means: trademark ownership applies only to the registered class. Registering a name in one class does not block its use in another. Trademark law does not give universal ownership. So, if rattle is registered in one class, for example, software or digital services, it does not automatically block media commentary, activism, education, or a different type of business in another class. What a trademark owner in Nigeria cannot do. Even with a valid trademark, the owner cannot stop people from using the word in ordinary language, stop criticism, commentary, parody, or public discussion, stop use in an unrelated industry, stop someone who used the name earlier in good faith, claim ownership of cultural or biological terms. Trademarks are meant to prevent confusion, not to silence people. Prior use and goodwill under Nigerian law. Although Nigeria operates a registration-based system, Nigerian courts recognize the importance of prior use and goodwill, especially under the law of passing off. If someone can show that they used the name publicly before another person registered it, the public associates the name with them, they have built goodwill around that name, they may still have legal protection even without registration. This is commonly enforced through passing off actions which protect reputation and identity from unfair takeover. What trademark registration actually does: in Nigeria, registration gives the registered owner statutory rights, makes enforcement easier, allows the owner to sue for infringement. But registration does not erase prior public use, automatically defeat goodwill built by another party, grant ownership of a word in all contexts, prevent legitimate fair use. If VDM has been using rattle publicly before any registration by another person, Nigerian law provides several options. First, VDM should compile proof showing when he first started using the name, how it was used, such as in media, activism, or branding, and public recognition of the name as linked to him. This includes videos, social media posts, interviews, campaign materials, and witness testimony. Secondly, if the trademark application is not yet fully registered, a formal opposition can be filed at the Trademarks Registry. Grounds for opposition include prior use, lack of distinctiveness, or bad faith. This must be done within the statutory opposition period. If the mark has been registered, VDM may apply for rectification or removal. Grounds include prior use, bad faith registration, misrepresentation, non-use. Even without registration, VDM may sue for passing off. This protects goodwill and reputation. Nigerian courts recognize this strongly where public association is clear. If coexistence is necessary, VDM can register a modified version, e.g., Rattle Movement or Rattle Media. This protects identity while avoiding confusion. Nigerian courts favor reasonable coexistence. If someone registers a name, knowing another person already uses it, with intent to block, intimidate, or exploit, such registration may be challenged as bad faith, which Nigerian law does not protect. In Nigeria, trademarks are not tools for domination. They are tools for fair identification in commerce. A trademark does not own a word, does not silence public use, does not erase prior identity, does not override goodwill. Disputes over names are settled by evidence, timing, public association, proper legal procedure, not by online arguments or intimidation. Osoria Asibor. C. All rights reserved. No reproduction without permission. Sharing is allowed with credit. This publication is for informational purposes only and should not be relied upon as legal advice.